trial about who killed three beautiful little kids, Cora, Dawson, and Callen Clancy. No mystery. No, it was their mother. Their mother did it. Lindsay Clancy did it. She admits it. She admits it. She says, I strangled all three of my kids. And she even gave the description how.
The prosecution's opening statement in the trial of Lindsay Clancy contained no mystery. She admits it. The record states, I strangled all three of my kids. The words entered the court record not as a theory, but as a stipulated fact, followed by a clinical description of the method exercise resistance bands, a basement, a luxury home in Duxbury, Massachusetts on January 24, 2023. A straightforward confession. An open and shut case. Except the state of Massachusetts then built its entire prosecution around a single, far more difficult assertion that she knew exactly what she was doing.
Carried out by a woman who understood exactly what she was doing and knew that it...
Think of a handwritten sign taped to a locked door that reads Do Now TNTR. But the person who taped it up is now sitting on the other side, calmly waiting. That is the visual distance between the act and the legal test. The state's burden was never to prove she killed her children. She had already done that for them. The state's burden was to prove she understood the nature and consequences of her actions, and that she knew the difference between right and wrong.
Was wrong. That's key. That is key. Knowing exactly what you're doing.
That phrase, knew it was wrong, is the hinge the entire case swings on. The jury was instructed that knowing exactly what you are doing when you kill is not the end of the legal question.
In December of 2022, in the month before the murders, Patrick said that Lindsay's medication changed, and Patrick described what followed as a, quote, big spiral. Patrick said that Lindsay made suicidal statements, and most significantly, Patrick said that she told him she had thoughts of hurting the...
Yet the trial record immediately split in two irreconcilable directions. The state called Patrick Clancy, Lindsay's now ex-husband, who testified that in December 2022, the month before the killings, Lindsay's medication changed, and what followed was, in his words, a big spiral. She made suicidal statements. She told him she had thoughts of hurting the children. She was being honest. She was saying something is wrong. These thoughts are coming into my head. She knew it was wrong.
But those thoughts appeared completely disconnected from the mom that he saw going through the motions every day, caring for the kids. He just sort of thought, it's incongruous, right? He testified, and I will read his words, what he actually said about that. He said it was very confusing.
But those thoughts appeared completely disconnected from the mother he saw going through the motions every day, making them lunch, putting them to bed. He testified it was confusing. One minute she voiced terror at her own mind, the next minute she packed school snacks. The paperwork already knew.
Patrick said that despite everything Lindsay had been going through, the day seemed to be actually one of her best days. He said Lindsay searched for a restaurant in Plymouth and asked him to pick up some takeout for dinner. She also asked him to make a stop at CVS as well because Cora needed some medicine. The prosecutors say those were not ordinary errands. Oh no. No, they were like part of the core of the case, according to the prosecutors. They say Lindsay deliberately sent Patrick on his way.
Then came January 24th. Patrick testified the day seemed like one of her best days. She searched for a restaurant in Plymouth and asked him to pick up takeout. She asked him to stop at CVS for Cora's medicine. The prosecution argued these were not ordinary errands. They were the architecture of opportunity. That she deliberately sent him away, created a gap large enough to kill 3 children without interruption, and did so with full awareness of the clock ticking on his return.
So that jury has now seen the route that Patrick took. They actually saw it for themselves. They were given one of those go-sees, a drive along, you know. They drove past the CVS, and they drove past the restaurant, and then they were taken inside the family's former home. Yes, former. Could you imagine living there? I could not. Some people do, not many, but the jury got to go there. They saw the basement where the children were found dead. They saw the yard beneath.
The jury was taken to the road. They drove past the CVS, past the restaurant, and were then led inside the family's former home. They stood in the basement where the children were found dead. They stood beneath the second-story bedroom window where Lindsay landed after cutting herself and jumping. The physical geography of the day became a piece of evidence, measured in minutes and miles.
And inside the house, in the basement, he found Cora, 5 years old, Dawson, 3 years old, and Callen, just 8 months.
Inside in that basement, Patrick found Cora, Dawson age 3 and Callen 8 months. Resistance bands around their necks. A father making these discoveries one after another.
Myself and Officer Hall, he proceeded to head in our direction, leaving that room. And at that point, he looked up and...
When police arrived, an officer asked what Patrick was saying. The answer entered the record. He looked up and he screamed, "She killed the kids."
He said she did not talk about the children. She talked about what she had experienced. She said she heard a man's voice telling her that if she did not do it then, quote, she would lose her chance.
But then, the parallel narrative began. Patrick testified that about a week after the killings, Lindsay called him from the hospital. She did not talk about the children. She talked about what she had experienced. She said she heard a man's voice telling her that if she did not do it then, she would lose her chance. Or words to that effect. The state had a confession. The defense had a voice.
The prosecutors say this all raises serious questions about whether she really intended to end her life or just get close to it, cover up, whatever. There's a big question there. The investigators found blood across the floor of the upstairs bedroom and a bloodied kitchen knife beside a cup bearing the words, "Because kids."
The prosecution pivoted to physical evidence. Investigators found blood across the upstairs bedroom floor and a bloodied kitchen knife beside a cup. The cup bore the words, "Because kids." The defense responded that white residue inside that cup came from pills Lindsay crushed before jumping. The state countered the cuts were superficial. An emergency room doctor testified they were not actively bleeding, that they did not require immediate treatment, that no artery or vein was struck. The implication was clear. She didn't really intend to die, just to survive the attempt and avoid accountability. The paperwork already knew.
There is something interesting that also happened in this courtroom. Her lawyer said, was Lindsay's body temperature 82.6 degrees when she came into the hospital? Think about that, 82.6. She was outside in the cold, right? And they had to acquiesce that, yes, her body temperature was that low. And the defense attorney asked, well, isn't it possible that maybe she wasn't actively bleeding because her body temperature was so low? And then came the other facts. Of course, remember I always said there's two sides. That eventually, when she warmed up, she did start to actively bleed. The gauze started to show it. And one of her cut marks was, I believe, 3 centimeters deep. That is deep.
Then the defense attorney stood and asked a single question about a number recorded on a hospital chart. Was Lindsay's body temperature 82.6 degrees when she came into the hospital? The witness acknowledged the record. The attorney followed, isn't it possible she was not actively bleeding because her core temperature was that low? And that when she finally warmed up, the gauze began to show active blood. One cut mark measuring 3 centimeters deep, requiring stitches. The same medical record that the state used to argue a faked attempt, the defense used to argue a body shutting down from exposure.
Here's the picture, and testified that the drugs that were detected in Lindsay's blood were within or near therapeutic ranges. So that means these aren't near overdose levels. It's not like she's, crushing up every single pill to, take an easy out. There is one drug called quetiapine, it's commonly known as Seroquel, that was found in the highest concentration, but even that was roughly 10 times below the level that's considered toxic. So it's hard to know what was going on crushing up these pills, or maybe the crushing wasn't going fast enough and she thought, hell with that, I'll do it the quick way. To hell with this is terrifying, I'm going out the window. You just don't know, but I think you will learn. Dr. Justin Brower, he went up on the stand and he told the jurors that people attempting suicide by medication commonly consume handfuls, right, of pills, like just, they load it up. And in his opinion, Lindsay's toxicology results were not consistent.
A forensic toxicologist then entered the picture. The drugs detected in Lindsay's blood were within or near therapeutic ranges, not overdose levels. One drug, quetiapine, was found in the highest concentration but was still roughly 10 times below what is considered toxic. Dr. Justin Brower testified that people attempting suicide by medication commonly consume handfuls of pills, and that, in his opinion, Lindsay's toxicology results with an attempt to overdose. The state's own witness opened a door the defense would walk through. Either she did not try to kill herself, or she tried in a way the toxicology could not easily measure.
Away from this with minor injuries. When she went out that second-story window, that fall transected her spine. She is permanently paralyzed from her waist down. She's in a wheelchair in court, you can see it. And she has not been out of a wheelchair since this all happened. And she will not be for the rest of her life. A surgeon testified that the damage was so complex that Lindsay had to be transferred to Brigham and Women's Hospital. And at that hospital...
Then the defense forced the jury to confront the medical record. When Lindsay went out that second-story window, the fall transected her spine. She is permanently paralyzed from the waist down. She is in a wheelchair in court, and she will not be out of it for the rest of her life. A surgeon testified that the damage required transfer to Brigham and Women's Hospital, resuscitation, and massive blood transfusions. The same woman accused of a half-hearted suicide attempt nearly bled to death on an operating table.
Long before those 3 little babies had their lives snuffed out in that basement, Lindsay was meticulously documenting a mental collapse in her own handwriting. This is what she wrote, completely overwhelmed in the fact that she was caring for 3 children, and it felt as though she were drowning every day. She became consumed by Callen's sleep schedule, and after allowing him to cry during sleep training, she wrote this.
And then there are Lindsay's journals. Long before the basement, she was documenting a mental collapse in her own handwriting. She wrote, completely overwhelmed, felt as though I were drowning every day. After allowing Callen to cry during sleep training, she wrote, hearing him cry for 1+ hours and not intervening just about killed me. She wrote that she told Patrick, I want to die.
Is trying to make something physically wrong with me. Again, these are things she wrote way before the killings, right? Not during to make it convenient. This was way before. She continued, I now have horrible insomnia and anxiety, which is causing depression. I don't know what's wrong with me. I want...
She continued, I now have horrible insomnia and anxiety, which is causing depression. I don't know what's wrong with me. I want help. I want to be well. These words were written not after the killings, not conveniently timed, but during the months of the downward spiral itself. The state's deliberate strategist left a paper trail of disintegration. The paperwork already knew.
Happens to only 1 in 1,000, as you pointed out. It's extremely rare, but her youngest was 8 months old, and postpartum psychosis can last easily for the first year after you've given birth. And really, she had the depression after her second child. I mean, the overlap with the Yates case is huge, and it's just amazing to me that
Postpartum psychosis lasts easily for the first year after birth. Her youngest was 8 months old. The overlap is not coincidental. It is medical.
Massachusetts used the substantial capacity test, not the McNaughton rule, which is far tougher. That's the one that Andrea Yates was under, that right-wrong test. Was she suffering from such a disease of the mind, a defective reason, as to not understand? But with substantial capacity, you don't have to know it, you just have to appreciate the wrongfulness of your acts. And I don't think she could appreciate the wrongfulness of her acts. Did she know it? That's a whole different test. But actually, Massachusetts has substantial capacity test, and that works well for Lindsay Clancy.
Massachusetts law uses the substantial capacity test, not the stricter McNaughton rule. The question is not simply, did she know it was wrong? The question is, could she appreciate the wrongfulness of her acts? It allows gradation. A person can know an act is wrong and still lack the capacity to appreciate what that wrongfulness means in that moment. The courtroom is now staring at a legal question that cannot be answered by photographs, toxicology reports, or even confessions. It can only be answered by what 12 jurors believe about the architecture of a broken mind. If a woman documented her own unraveling for months, asked for help, was medicated, was hospitalized, and then did the unthinkable, at what point does the legal system decide she crossed a line she could actually see? The public record, the medical files, the journals, the 911 call, is available. Read it. Then ask yourself not whether she did it, but whether under the law she could appreciate what meant.